Thank you very much for joining us today. My name is Ian Scott, and I am the managing partner at Scott Legal. We are a full-service immigration law firm that focuses on a number of different types of visas, employment-based visas, family-based visas, waivers, and we also offer services for humanitarian relief. Today, we're going to spend some time talking about the people who have a non-immigrant visa, such as a TN, an E2 visa, an O1, an H1B, and ways that they can move to a green card. And we're going to go through the various green card categories, and we're going to talk about them in that context. A few housekeeping items. This webinar is being recorded, and you will receive a number of things after the webinar, one being the actual recording. And you will also get a link where you can download guides to the various types of visas and green cards that we're going to talk about today. We'll also send a link where you can set up a consultation if you have any follow-up questions, and we will also send you a copy of the PowerPoint presentation. So without further ado, let us jump right into the presentation, and we'll first talk about the green card system in the United States because the system is quite a bit different from the systems in other countries. So, for example, when you look at a country like Canada, for example, and the UK, they have points-based systems where if you want to apply for permanent residency, then you get points for a number of factors. So, for example, it might be that you get points for speaking the language, you might get points for how long you're in the country. You might get points for your educational background or work experience. And then when you have a certain number of points, you can apply for permanent residency. But in the United States, it's quite different. And instead of that, they just have a list of green card categories. And if you're eligible for the green card categories, then you can apply. And we're going to, and those are the ones that we're going to focus on. The two major areas with respect to green cards are family-based and employment-based. There are some other areas that we'll touch on closer to the end. But the primary areas are family-based, and we will delve into both of those. The family-based are further categorized into immediate relative and preference categories. And then the employment-based categories are EB1 through EB5. The only one we're not going to talk about today is EB4, which is a religious-based green card, and our firm doesn't do those, but we will touch on the other categories. So let's first talk about family-based, and this is a way that a lot of people move from a non-immigrant visa to a green card. And as I said, that the categories are further broken down into immediate relative and preference-based categories. Now, immediate relative isn't exactly as we think. For example, a sibling isn't considered immediate relative. It's just a defined term. So an immediate relative would be a U.S. citizen marrying someone, a spouse, or it could be a U.S. citizen over 21 that is sponsoring their parents. And the reason this is important is because the immediate relative categories don't have the weights that some of the other categories, the preference-based categories have. The green card is always available. So that doesn't mean that there's some delay in terms of they still have to process the application, but the green card is available. So it does sometimes cut down the wait. So as opposed to a preference-based category, so that might be a U.S. citizen sponsoring their sibling. Now, when I say that the immediate relative category, there's no wait, contrast that to the preference-based category of U.S. citizens sponsoring a sibling where there's a 14 or 15-year wait. So and all of the preference-based categories right now are delayed. So that means that the green card is not available because what ends up happening is that every year there are a certain number of green card categories certain number of green cards that are available to be issued by a particular category. And then once those categories are used up, then unfortunately you're in a situation where you get put in a queue, in a line. So, and there are significant backlogs in all of the preference-based categories at this point in time. Now, with all of the green card categories, and I think that this is the case, I think this is the case with all of them, it's either a two-step system or a three-step system. So the person is going to file, we'll call it an objective piece. So if it's a family-based petition, they're going to file an I-130. And they're really going to be getting at, for example, if you're marrying a US citizen, you're going to be getting at, is it a real marriage? If you're getting a preference category for a family member, then you'll have to prove or provide documentation, birth certificates, etc., to show the familial relationship. So then now after the first step, there's going to be either two or three more steps. So the second step is either going to be doing what's called adjustment of status. So if you're in the United States, you can do that. That's filing an I-485 petition. Or if you're outside of the United States, or sometimes when you're inside the United States, you're going to do what's called consular processing. Now, the one you choose is really going to depend on your ability to stay in the United States or not, because if you're choosing employment-based, if you choose a adjustment status, then you have to file travel authorization and employment authorization, and it could take 6 to 9 months to get the travel authorization. You do have to remain in the United States while you're waiting for that. So sometimes people can't do that, so they have to process at a consulate. And then I said that it could be 2 steps or 3 steps, and that it could be 3 steps in that for some green card categories, so under the immediate relative, for example, where U.S. citizen is sponsoring someone, they also have to file something 2 years after they get the green card to show that the marriage is still legitimate and it's removing the conditions. So the green card is issued for 2 years, and then you have to file something after that to show that you still meet the requirements. And so that's a 3-step process. So in terms of moving from a visa, we have a lot of people, they might be, for example, here on a TN or an E2 visa, and then they meet a US citizen and marry, and that could be a mechanism. We've had people on an E2 visa where their parents had sponsored them, but there was a delay because the parents sponsoring children over 21, that's a preference-based category where there is a delay. But so they had the E2, and then when they were able to get the green card, they moved to the actual green card. So now let's move into the employment-based categories, and we're going to start with EB1A, extraordinary ability. And now what we see here is we see the people who tend to apply for a green card under the employment-based categories as people who are on an O1 visa. So there's a visa called O1, it's O1A or O1B, and it's also extraordinary ability, but in the non-immigrant visa category. So the O1A in particular, the criteria are very, very similar to the EB1A requirements listed on the sheet. There are 8 of them, and in order to qualify, you have to meet at least 3 of them. So someone who meets the O1A requirements, could have a shot at meeting the EB1A, although the EB1A, it's more. So if you're getting the green card, it would be the non-immigrant category squared, right? So if you had publications, you'd want more publications. If you had an award, you'd want more awards. So it's always going to be they're looking for more because they're giving you the green card, even though on paper the requirements look the same. So, for example, if we look at some of them, they say if you command a high salary, they're saying that, well, people who command a high salary as compared to their peers in that particular field, the reason is because they've risen to the top of their field. Because that's what this is all it's trying to do. It's trying to show that you've risen to the top of your field. If you're judging the work of others, when you think of American Idol, the judges that they have are all accomplished, singers, right? So that's why they're judging the work of others, because they're supposed to be good themselves. So if you're judging the work of others, that's something that shows that maybe you are accomplished. And getting awards is another one. If you've been awarded different things, especially if those awards are coming from prestigious organizations, like someone who wins an Oscar or a Grammy, or People's Choice Awards. Those are all things that could impact someone's ability to do an EB1A. So the next one we're going to talk about, and we are going to talk about how to apply for an EB1A, but we're going to do it after we do the EB2. The next one that we're going to talk about, an employment-based category, is national interest waiver. And for this particular one, we're going to start with the threshold requirements, because EB2 is the category that this is under. Remember I said that we go EB1 through EB5. EB2 is the category. Now for EB2, it's subdivided into national interest waiver and something called PERM, where PERM is a company sponsoring you for a green card, which we'll talk about in a minute. Now, for EB2 category, though, you do have to meet the threshold considerations and have either an advanced degree, which is a master's degree or higher, and the master's degree or higher has to be in the area of your particular endeavor. Bachelor's degree plus 5 years experience. And again, the degree and the experience should be in the area of the endeavor, or exceptional ability. So they list out some criteria and say if you meet three of them, these are not as hard to meet as the extraordinary ability that we talked about earlier. But that's how you could qualify. So that's just the threshold requirement. So something you have to do even to be able to consider meeting the actual national interest waiver requirements. So then we move to the actual requirements, which are based on a case called Danisar. And what happens here is that you have to show that whatever your proposed endeavor is of national importance, substantial merit and national importance. Now, when you're doing a national interest waiver case, the very, very first thing that you're going to do is map out exactly what your proposed endeavor is. That's going to be very, very important. And with that, it could be that you're saying that the national importance is that you're going to create jobs. You could be, developing a new protocol. You could be developing artificial intelligence technology that's going to revolutionize something. You could be developing a vaccine. You could be starting a cybersecurity company to protect people against cyber attacks. So, and as I said, it could be jobs as well. And so if it was jobs, you would want to make sure that the economic impact was significant, that there was a significant benefit to the community. And you are going to often, with this particular type of petition, you're often going to get expert letters that you're going to include into the petition, and the expert letters can talk about why your endeavor is going to be nationally important or could be nationally important, and also the expert letters can be used for other things. The second requirement is that you are well positioned to advance the endeavor. So that's going to look at your track record. It's, they're not just going to take your word for it. So if it's an entrepreneurial endeavor, you'd want to see a business plan, but you'd also want to see that the company is well funded. You'd want to see that the company has contracts, employees, things like that. If it's another endeavor, like let's say you're developing some type of artificial intelligence, the government might want to see a patent, or they might want to see the application has been developed and is already generating positive feedback. The other important thing is showing a very strong track record of achievement. I think that's very important for Danisar cases and meeting the second prong. And then this last requirement is that you have to show that the government should waive the labor certification, because that's what's being waived. Is the government has said already that they feel that protecting U.S. jobs is nationally important, but here you're showing that even though there's that importance, that on balance, you should still be granted the national interest waiver. Now, with both of these, the EB-1A and the national interest waiver petition, you can file these without a job offer. So that's one great thing about these, is that you can self-petition for both of them. And these both have a two-step process where you could file the I-140, which is going to be the objective part of the petition, which is going to show that you've met the requirements. So for example, if it was EB-1A, you've met at least 3 of the 8 criteria that are listed there. And then once that's been approved, or if the category is current, you can file the I-485 if you're in the United States, and or do consular processing. And as I said, if you are in the United States and you're filing an I-485, then you can file the work authorization and travel authorization. Now, keep in mind that the I-485 can only be filed if the category is current. So right now, the EB-2 category is not current for any country. The EB-1 category is current for most countries. India and China, it's not, but sometimes you do have to wait for it to become current. And the EB-2 category, for most countries, it's delayed by about 1.5 years. Okay, so now let's look at, now let's look at EB-2 and EB-3 perm. So this is when a company is sponsoring you for a green card. So it's EB-2, I mentioned before that EB-2 is broken out into the 2 sections. And EB-3, it's just the distinction here is whether you're being hired as a professional or unskilled worker. And this does require the company to sponsor you. And this is a 3-step process where the first part of the process is with the Department of Labor. It's called PERM. So you're developing a job description. That's going to be key. The job description can only be the minimum requirements for the job. And then there's going to be a wage that's associated with it. And you're going to go through a pretty extensive recruitment process to get people to apply for the job. And that's, it's an interesting thing because even though there's no actual job, right? You're actually recruiting for the job. People are applying for the job. And but there's not really an actual job. Um, and once you get that back, and you submit it to the actual Department of Labor perm, you get that back, and if it's approved, if it's certified, then you can file the I-140 petition, and again, looking at the I-485 or the consular processing. So that's something to keep in mind. So the next area that we're going to talk about is EB5. So this is an investor-based green card. So the first thing you have to kind of look at is whether or not you're going to invest in a regional center or do direct investment. So regional center would be the situation where you have a company that is like, let's say a company that says that they want to build a chain of hotels or something like that, right? And or even one hotel, and then they say they're going to raise $100 million of capital, and then they're going to get investors and participate in the EB5 program. Then that's something that could work here. Whereas direct investment would be someone investing in their own business or someone else's business and saying that they're going to create 10 full-time jobs. So the amount here is you're going to be investing 800,000 or 1,050,000 in a business. A difference between the 800,000 or the 1,050,000 is that if it's 800,000, then you're investing what's called a targeted employment area. So the TEA is going to be an area where the unemployment rate is at least 1.5 times the national average, or a rural area. And the investment has to be investment that comes from funds that you personally hold. The government's very particular about this. It can't be that you have an E2, because what we have here is a lot of people that are on maybe E2 that are moving to EB5. They have their own business, and then they're investing maybe some more into the business and moving from E2 to EB5. But if the business is operational and it's making money, you can't just say that, okay, the business has made $1 million and I've spent it, and now the retained earnings constitutes my investment. That doesn't work. It has to be money that was outside of the company in your possession and then invested into the company. The business does have to also create 10 jobs. That's full-time jobs, not part-time jobs. For regional centers, they can benefit from indirect employment, which is something where, let's say, the restaurants or other establishments that opened around the example of the hotel that I gave, then an economist can talk about the job benefit related to that. But if not, if it's a direct investment, then it can only be direct jobs. So also jobs that this particular company where it's actually hired people. And you need a detailed business plan, both a regional center and a direct investment. And the money that you invest has to be linked to job creation. So the timing of the investment really matters. And the documenting of the full-time positions and qualified workers is going to be really important. Source of funds is nothing like other petitions. It really is a bear. It's much more of an audit. It's equity investment that you're going to be doing. And the source of funds, like I said, if you have an E2 and you have an approved E2, the source of funds is, relatively straightforward with respect to that. But EB5 is very, very different. EB5, the filings, there's going to be the objective piece, which is the I-526, which shows that you have submitted you've made the investment of the million or 800,000, and that you have a plan to create the jobs. And then we're going to be looking at whether the category is current again. And this is a 3-step process, because once you have had the green card for 2 years, then you also have to file an I-829 to show that you actually have been able to create those US jobs. So then, and one other thing I want to point out is all of these areas, although we're going through them very briefly today, we do have separate webinars on every single one of these topics. So you can go to our YouTube channel and look up the webinars, or sign up for future webinars on these topics. Some other green card options, diversity lottery, that I believe that's actually happening. It was supposed to, normally the sign up is in October, but I think that they were making some changes. So the sign up, I think, is going to be in November. So keep your eyes up for that. There are other humanitarian-based green cards that are around, like so. If you're a victim of domestic violence, or you've seen a crime and you help the police, and then of course we all always can hope for immigration reform. So the timing, when you're doing EB-5 and any of these visas, the timing is very important because you always have to make sure that you have underlying status. So if you're on a TN and your company says, I want to sponsor this person for a perm, it can be done, but you do have to look to make sure that you are in the situation where you don't have, that you're able to continually maintain underlying status, right? So, and similarly for all of these categories, that is something that you have to do. And because the status is going to impact your ability to travel on the visa, your ability to stay in the United States, your ability to work, et cetera. So all of that's going to be all of that you're going to have to take into consideration. And sometimes people do have parallel green card strategies where they, maybe have two different green cards that they're going for, and in case one falls through. And you do have to always look at the visa that you're on, like a visa like a TN visa, or if you're on B1, B2 or something like that. They're not dual intent visas, whereas an L1 and H1B are. So planning really, I think, is the key for all of this. So that was really the shared remarks that I had. As I said, what we will do is we'll send you a copy of this presentation, a copy of the video. For all of these areas that we talked about, there are guides that you can download, and we'll send you a link for that as well. I'm just looking to see if there are any questions. I know we covered a lot of material. Looking to see if there's any questions, but certainly if you have additional questions, I don't see any in there, but certainly if you have additional questions, you can set up a consultation with us, and we can go through those questions. Excellent. So thank you very much for joining today. Bye bye.